Children, Young Persons and Their Families, Youth Courts, Jurisdiction and Orders Amendment Bill, committee stage, continue.
I declare the House in committee for further consideration of the Children, Young Persons and Their Families, Youth Courts, Jurisdiction and Orders Amendment Bill. Mr. Chairman.
Mr. Speaker. The House in committee for further consideration of the Children, Young Persons and Their Families, Youth Courts, Jurisdiction Orders Amendment Bill. Members, when the committee last considered the bill, debate on Part 2 had just commenced. Jacinda Ardern had the call, and she has 4.5 minutes or thereabouts remaining, should she wish to avail herself of that opportunity.
Yes, and I do. Thank you, Mr. Chair. I'll try and make it a little bit more if I'm able, because I do have a lot to say on Part 2. I think Part 2, Mr. Chair, demonstrates the far-reaching effect of an issue that's been the source of quite a lot of discussion throughout the debate, and that is the extension of the 12 and 13-year-olds being captured, because that crosses over into the Criminal Investigations Bodily Samples Act, which we find in Part 2, and has some impact on that Act. Now, those on the Justice and Electoral Committee will know that we've only recently made significant changes to the Bodily Samples Act, and the way that children and young people were captured in that Act was the source of quite a lot of discussion, and I want to touch on that in my contribution, because as Chester, the member of the Social Services Select Committee has pointed out, it was his view that the provisions around 12 and 13-year-olds being able to go through the youth court was essentially a matter of filtering, a matter of expediency. But I think this part points out that it has much more of an impact than that. Now, the Part 2 cross-references subsection 1A in the primary legislation around the Criminal Investigations Bodily Samples Act 1995. And I want to just reflect quickly on that section, which reads that, however, a suspect who is a child or was a child at the time an offence in relation to which he or she may not be lawfully prosecuted, being an indictable offence other than murder or manslaughter, was committed, may consent to the taking of a buccal sample as a result of a Part 2A request. So basically what we see there is that there are elements of compulsion available to the police for the taking of buccal samples for offences such as murder and manslaughter, because we acknowledge that for 12 and 13-year-olds in our system as it stands, those children are already able to be taken through a higher level of court. So that section essentially says, well, for everything else, compulsion does not apply, it's voluntary. And then we come to Part 2, and I don't know that there was too much, I don't recall there being great lengths of discussion in the Select Committee about this part, but I want to talk about what is inferred by this part, because if we look here, it says the replacement clause of 1A says that, however, a suspect may, in relation to an indictable offence, consent to the taking of a buccal sample as a result of Part 2A, request if the subject is a child or was a child at the time of the offence is alleged to have been committed and cannot lawfully be prosecuted in relation to that offence because it is not an offence of any of the following kinds. And before in 1A we just had the offence of murder or manslaughter. Now we of course have an indictable offence as well, and also going on two more criteria, that is alleged to have been committed when the suspect was aged 12 or 13 years, and for which the maximum penalty available is or includes imprisonment for life or for at least 14 years. I just want to seek some clarity for the Minister around this clause. I accept I may have misinterpreted here, but I don't believe I have. Prior to this, we had the case where compulsion could be applied for murder and manslaughter. Now we're saying that for everything outside of murder, manslaughter and indictable offences with a penalty of up to 14 years, everything else is voluntary. But within that, compulsion can be applied to 12 and 13-year-olds. That's the only assumption that we can make by the reference in this Part 2. So I would like to seek some clarity from the Minister over this. And the reason for that is this. When we discussed the Bodily Samples Bill in the Justice and Electoral Select Committee, the direction from the Minister of Justice was clear, and that was that he held grave concerns about the creep that can occur, could have occurred on the basis of that legislation. And direct reference was made to this idea of we don't want samples being taken in the backs of cars, police cars, with young children without guardians who are there or available. And we went to great lengths in that bill to make sure that we cross-referenced the CYFS, the Children's Young Person and Their Families Act, and made sure that we carried over the provisions that apply, Mr Chair,
Jacinda Ardern.
the provisions that apply to an interview situation where a guardian or a caregiver must be given the opportunity to be present for an interview. We carried over those provisions for certain classes of buccal samples being taken for young people. Now, it seems to me that those same kinds of protections for 12 and 13-year-olds, we didn't discuss, again, the broadening of that power for those groups. And I have great concerns about that. And I would ask the Minister to clarify the intention there, whether or not also that change was discussed with the Minister of Justice. I certainly think it would have been a clause and proposal that would have been gratefully received and discussed by the Justice and Electoral Select Committee when we originally discussed the Bodily Samples Act, because I think we would have had something quite substantive to say on that extension, on that broadening of scope and power. And I guess, again, that all comes back to the flow on, as I mentioned, of broadening out the way that we treat 12 children in our laws, in our legislation, because this is not just, again, a filtering or a streamlining of our youth court and family court processes. It has a much broader effect. And in fact, the importance of this clause is reflected in the fact that we now, as a consequence, are in breach of our obligations under the UN Convention on the Rights of the Child. And I would like to hear the Minister's thoughts as well on the impact of these changes on that convention, because recently, very recently, I know the government had an opportunity to appear before the UN Convention on Human Rights in Geneva and did not mention this bill. Didn't mention part 1, let alone part 2. And not only were we already in breach based on the way that our 17-year-olds are treated in the youth justice system, rather than fixing that, we broadened the whole thing out and brought 12 and 13-year-olds just for good measure. And they are children, as we have continually highlighted throughout this debate. They are still children. So that is a question that I'd like to put to the Minister, because, and the reason that the UN obviously has a broad definition of who it considers to be children in that convention, and why it's important they be treated differently is based on research, is based on evidence, is based on around the ideas of brain development, the impact of those young people being in what's deemed a pseudo-adult criminal justice system, and the long-term impact on those children and being exposed to an overtly punitive form of criminal justice. So I would like to hear the Minister's reflection on our obligations, because part 2, I think, is in direct contravention as well of that convention. And I do know that, for instance, Simon Power, either in the lead-up or after his appearance before the Human Rights Commission in Geneva, stated, it's important, and I think this is a good quote, because I do agree, it's important to front up with our own situation so that we can credibly discuss the challenges facing other countries. So there's an acknowledgement there by the Minister that in order to maintain our credibility on the international stage, not only do we need to be present and be ready to be scrutinised, we also have to hold our own in this forum. We need to make sure that we maintain the bar that's set by the UN, and in many other respects we do, but this is a fundamental failing. And I do think that it's slightly disingenuous to have said that we can only credibly discuss the challenges facing other countries if we front up with our own, and then not even discuss what we were debating at that time back in the New Zealand parliamentary process and in Select Committee, and that is these fundamental changes that are made through the Children's Young Person and Their Families Youth Courts Jurisdiction and Orders Amendment Bill. So I would like to ask the Minister if she wouldn't mind addressing the points that I've raised around the Criminal Investigations Bodily Samples Act and the impact of the changes in that section, because it is reasonably detailed. I think it's mainly the changes here come through inference rather than being a direct reference